This is Michael Popok, so it must be time for Legal AF After Dark, the only criminal trial that's likely to be held against Donald Trump before the November election. The Manhattan District Attorney's Office case involving business record fraud, the Stormy Daniels hush money cover-up affair. It has it all. Fraud, business records, Donald Trump's very short sexual contact with Stormy Daniels, Michael Cohen as a lead witness. We break it all down for you on the most recent episode of Legal AF. Take a listen. Let's get right into it. Let's, listen, we got to get off the mat and move forward. That's not the decision we wanted, but that's the decision we have by the United States Supreme Court, which effectively takes off the docket the case that we all think is the most important case to go to trial before the November 5th election. It's just not going to happen. So, but we do have a case. It may not be the case that everybody wanted, but it's the case that we're going to have against Donald Trump. First to indict, first to try, Manhattan DA. And now the lawyers there on both sides are filing their motions. I'll do the ones for Donald Trump, but why don't you do the ones that the Manhattan DA? You want to do the ones that Manhattan DA filed or the ones that Donald Trump filed? Why don't you do the Manhattan DA ones? You did a good hot take on the gag and the juries and all of that, and I can kind of wrap in with the motions in limine. Does that make sense?
Yeah, sure.
Okay, hit it.
You want me to go first?
Yeah, please.
So the Manhattan DA's office, the trial lawyers there are clearly getting ready for trial by filing pretrial motions in limine. And so that's how you kind of know that trial is about to start, because just from the timing of it, and these are the pretrial motions that are being filed. And they filed two motions in particular that kind of go hand in hand. They're very similar. They're two sides of the same coin, if you will. One was for a gag order of Donald Trump, and the other is for an anonymous jury. And essentially what they're asking for is a protective order. It was a protective order motion seeking the prohibition of disclosure of juror or prospective jurors' home addresses or business addresses other than to counsel of record for the parties. So meaning the lawyers can get the addresses so that they can do the research, because that's what lawyers sometimes do when they're engaging in pretrial research with jury. It's called voir dire or voir dire in some parts of the U.S., but we call it voir dire here in New York, and that's just another word for jury selection. I think it's a French word, actually, not a Latin word. But anyway, and so they're going to do a juror questionnaire, and jurors are going to put their names and addresses, and the lawyers will do research and look into find who these people are in an effort to kind of learn more about them. And so number one is they're asking to prohibit the disclosure of this information from Donald Trump himself. And only allow it for the lawyers, and so that way the lawyers can do research. And there is law in New York that allows for this, and so this should be granted, and that's why they made this their number one argument, because they know it's fairly strong, and that will be granted. Now, the second argument that they asked for, the second thing they asked for, was to prohibit disclosure of the jurors' names other than to Trump and his lawyers and to the prosecutors. So that's a little dicier, because if you remember, in the E. Jean Carroll case, Judge Kaplan did it federally, because federal law allows for that. But in state court, that's a lot trickier, and in New York, it's a lot trickier and more difficult to do, because when you in general, an anonymous jury where you don't give the names to anyone, that signals to the jury in a way that this defendant is so dangerous that you don't want him to know your name or your address or any information about you. That could be prejudicial, because if that's how they feel, they're not going to go back into the jury room and necessarily give a fair and impartial assessment of the facts. So that's a little dicier whether they'll do that. They should do that. Otherwise, why does the public have to know who these people are and know their names? So I think the judge might actually consider it, because there's such a long record here about threats, et cetera, in various jury cases and jury trials and proceedings. And they cited to them. They cited it to the Roger Stone case, for example, where Donald Trump came out and started attacking the jurors in that case, calling them totally biased and tainted and disgraceful. Said the forewoman, look at her background. She hates Trump. She hates Stone. She's totally biased. So they put that, the Manhattan DA's office put that in their motion, that case. And they also went through all the times that Donald Trump repeatedly attacked, whether it was the Fulton County grand jurors, calling them names, calling them illegal kangaroo court, et cetera. Or in the E. Jean Carroll case, the first one, where he was calling them hostile and partisan and witch hunt and on and on. And, they also cited his longstanding history of attacking witnesses, investigators, prosecutors, judges, court staff. We saw that. And I mean, the thing is, it's not like this is speculative at this point. They have a body of work to show the judge to say, look at all these cases, look at how he does it. He goes after people's families. He goes after jurors, et cetera. So that comes to the second part of this, the other motion, which was the gag order. And they were very clear about tracking the language of the gag order in the DC presidential immunity, the one we just talked about, the Tanya Chutkin Jan 6 case. That gag order was appealed to the DC Circuit, and it was refined, and there's language that they're comfortable with. And so the Manhattan DA's office made sure to track that language exactly, so that it can withstand appeal. And again, cited this long-standing history of attacking witnesses, investigators, prosecutors, judges, court staff, family, blah, 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 everybody's wives and families, and Judge Engoron's clerk and Michael Cohen's wife, et cetera. I think he's going to also give him this gag order because of it, with one caveat. They asked for, the Manhattan DA's office asked for a prohibition on attacking witnesses as well. And I get why they did it, but it's not just attacking, but it's also commenting, right? And potentially influencing the trial. And the only caveat and question I have is, will the judge grant that? Because, or will he modify it and say, you know what, I'm going to oppose a gag order on everybody, including the prosecutor and the witnesses, et cetera? Because I think it would be difficult as a judge to say to Trump, okay, I'm gagging you and I'm gagging the defense team, but Michael Cohen can go out and continue to talk about the case, talk about you, talk about stuff, and that Trump can't respond. Also, if Michael Cohen continues to talk about the case, and obviously he's on this network, and he's on the MeidasTouch network, and he has every right to talk about it. And in fact, I think his talking about it is largely responsible for why these cases are being brought. He's kind of a whistleblower more than anything else. But, I think at a certain point, the judge will say too much talking about it extraneously, extrajudicially outside of court could also influence or impact jurors. So I could see that the judge would potentially even go further and not only grant this gag order, but also potentially gag others as well. What about you, Popok? What are your thoughts on
we're
that?
going to have Michael Cohen on one day. I went on Michael Cohen's show, Mea Culpa, and it's up in audio. I'm not sure how Michael exactly puts up his video versions, but we're going to cross him over. I mean, right now he's the bride at the wedding and the body at the funeral. Everybody's got a Michael Cohen motion from the Manhattan DA's office, who filed a motion as among their many motions in which they want to make it, they want the jury not to learn about or not have Donald Trump argue about anything related to the federal prosecutors when they were under Donald Trump's Department of Justice, and their opinions one way or the other about Michael Cohen. I mean, listen, Michael Cohen paid his debt to society. Michael Cohen pled guilty, convicted, of a couple of felonies. There's some perjury in there related to some of those things. This is like received wisdom. This is like known facts. And Michael will have to deal with that in cross-examination and in direct examination when they put them on to admit to it. But they don't want like a third party's hearsay analysis of Michael Cohen as a witness. In this case, the U.S. Attorney's Office in the Southern District of New York, which was ultimately under the Department of Justice, led by Donald Trump's attorney general, to like that shouldn't come into evidence. On the other side, Donald Trump doesn't want Michael Cohen to come in at all. Oh, he's a convicted perjurer. He can't believe a word he says. He shouldn't be allowed. Use your gatekeeping function, judge. Keep him off the stand. That's not going to happen. But you see where Michael Cohen had a good comment in his social media where he basically told Todd Blanche, the lawyer for Donald Trump, to F off related to his attempts to take him out of being a witness. And the reason that Michael Cohen is so important is there's not a lot of moving parts about the scheme that's at the heart of the Manhattan DA's office's indictment. It's a catch and kill program led by David Pecker of the National Enquirer, a friend of Donald Trump, who had devised the plan with Donald Trump's consent and Michael Cohen's involvement. They paid off the people that Donald Trump slept with by having them get a lot of money. The going rate was about 100,000, 130,000, and then had these women sign non-disclosure agreements in return to catch and kill, catch the story and kill it. And then, so Pecker's going to have to testify. And then when it came to Stormy Daniels, Pecker didn't want to lay out the money because he'd already been burnt by Donald Trump once. So Michael Cohen laid out the money. So Michael Cohen's got to testify that he laid out the money to bribe Stormy Daniels, the hush money part, and then worked with the boss, Donald Trump, and Alan Weisselberg, the disgraced felon of a chief financial officer who's basically a perjurer himself, to disguise the payments on the books and records of this New York corporation to help candidate Trump, who was running for office against Hillary Clinton, hide the fact that he was making bribe payments to his mistress, not the right word, his 30-second stand with Stormy Daniels. So you got to have Michael Cohen. You got to have some version of Alan Weisselberg, either in prior testimony or get him up on the stand again. You got to have David Pecker. You got to have people around the office that we now know who they are from the New York Attorney General's case. All those low-level, mid-level vice presidents that saw all this happen. We got to bring them back in because they're going to testify about the bookkeeping and the record keeping. And then the other thing that I keep saying the Attorney General, it's on my mind, the Manhattan DA's office wants to not allow Donald Trump to argue to the jury is about whether this was or was not a Federal Election Commission, an FEC, federal election law violation. They need to prove, in order to make it a felony, even if an E-level felony, a low-level felony in New York, that there's two crimes. It wasn't just because the books and records violation is a misdemeanor. If you fraudulently keep your books and records in New York, that's a misdemeanor crime. To ratchet it up to a felony, there has to be in the commission along with another crime. The other crime is a federal election crime, but they don't want Donald Trump to be able to argue by bringing in an expert that he didn't violate the federal election law or what. So they got an argument that Judge Merchan's going to have to listen to about why that particular thing is irrelevant, and they don't want any of the defenses along that line to be brought in. So there's going to be, and they don't want Stormy Daniels on the Trump side, just to keep balancing this argument. They don't want Stormy Daniels to take the stand because they don't want the jury to be like distracted by the fact that she got paid. But she got paid. They're going to argue that what does that have to do with how he recorded it in his books and records, unless Stormy Daniels was involved with like keeping the books and records. And the other argument is the jury's got to hear the full story about the affair, the cover-up, the motive, the modus operandi, why Donald Trump did this, what was his incentive to do it, and all of that. So Merchan's going to have to pick through all of these motions right before the trial, maybe on the first day of trial, probably before, to give the parties time to get their cases ready. But this case is going to trial. I know there's speculation that now that there's this decision by the Supreme Court to that they find interesting the issue of whether a president at the time can commit a crime and be indicted for it, somehow backs up into this case. But I just don't see how that's even possible, because this case has to do with pre-elected activity, campaign activity of candidate Trump before he was elected, having nothing to do with him taking office in his official position. So the way the Supreme Court has even framed the thing they're interested in wouldn't seem to apply. Now, is Donald Trump going to wave around, get ready, everybody go get Pepto-Bismol, because we're going to go have to watch the next 3 days of everybody in Donald Trump's world and all of his lawyers getting on all the social media and on news. We won. We were right. There should have been a stay. He can commit crimes while he's president and get away with it. It's allowed.
You know what really pisses me off about that, though, Popok? Sorry.
No.
Look, this just came down, so I'm processing it,
Yeah.
But what really pisses me off about the fact that the Supreme Court is doing this, number one, is even if Donald Trump ultimately loses the argument, okay, he wins because there's no trial before the election. So this is a huge win for Donald Trump. But what pisses me off to no end is the fact that Jack Smith saw this coming. Jack Smith tried to leapfrog over the DC Circuit, go to the Supreme Court to say, okay, Supreme Court, I know this is an issue. I know it's a big issue. I know Donald Trump has packed the court with conservative MAGA justices. Therefore, you're probably going to take this case anyway, even though there's no merit to it. So let's just go straight there. Let's just go and let's skip over the DC Circuit and we'll go straight to the Supreme Court and just do it like that. You'll hear it, you'll brief it, and just get a ruling one way or another so that we can have a trial. And unfortunately, they say, no, we'll just let the DC Circuit rule first, which how long did that take? It took months. So we ate 3 months of time for that, right? And that was the 3 months that Judge Chutkan said, well, since we're pressed pause, I have to give them 3 months back. So we all keep saying, okay, the trial is going to go in 3 months after we finally, this stops.
Your point is well made.
Or whatever. Yeah, whatever it was. But the fact of the matter is, if they were going to do this anyway, they should have just taken it then. They should have just granted cert then. But they didn't.
They don't like it that way. They want to solicit.
No, you know why they don't like it that way?
Yeah.
No, they don't like it because this way they can just say, oh no, they don't want this trial to happen. That's the thing. The MAGA Republicans don't want this trial to happen because if the facts come out and people swear under oath and the trial happens, there will be a conviction. And so now, guess what? Donald Trump is going to run for president without having there be a trial. If he wins for president, guess what happens to this case? He appoints the attorney general. This case goes bye-bye. He pardons himself, everybody else under the sun, and he opens the jails of all the Jan Sixers, that including Enrique Tarrio and all those people. The jails open, and that's who's out in the. This is astounding.
He wins the presidency. Forget what happens in the Chutkan case. That would just be an interesting side note. He wins the presidency. He's pardoning himself, and as you said, it's going to be like what's that Batman game with the jail and Batman? He's just going to open up. It's like the Joker. He's just going to open up all of the
jailbreak.
Yeah,
the giant 1,000 people, right? 1,000 people were prosecuted. He's going to do 1,000 pardons, and he's going to do it publicly and call them patriots.
So if you're upset by some of the things that we need to explore on this midweek edition, and I think this just proves to you, we don't blow smoke or sunshine on this network. I report, and Karen reports, and Ben reports things, whether we like them or not, that we think is important at the intersection of law, politics, and justice. But if you don't like the result, after you're done licking your wounds over it, go help get Joe Biden elected. Well, if you like lawyers who know what they're talking about at the intersection of law, politics, and justice, including former prosecutors for the very office that's taking the case against Donald Trump, you've come to the right place. It's called Legal AF. It's only on the MeidasTouch network here on this YouTube channel. You knew that. Don't change the channel. Don't change the dial. Stay right here. Every Wednesdays and Saturdays at 8 p.m. Eastern Time, we're on doing a live version of Legal AF. Yes, the title means just what you think. And then we have we put our podcast on audio podcast platforms of your choice. If you know all about Legal AF, welcome back. We appreciate you. Take that clip, send it off to people in your family. It's sort of a gateway podlet. Ask them to join our audience. If you have no idea what I'm talking about or who I am, I'm Michael Popok. That was Legal AF, and we invite you to join our audience. So So until our next Legal AF, until my next hot take, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.